Right, let the record reflect state's attorneys present, defendant, and defense counsel are present. Anything we need to take up before we bring the jury in?
Judge, I did not subpoena the 911 custodian of records. I'm trying to find the business records affidavit that was previously submitted with regard to the other pending matter associated with Mr. Cooper, who I believe the state felt call. And so I will need an opportunity to get that custodian of records here with regard to the 911 call in that case.
Was it filed with the business record affidavit already?
No, Judge, if there was a business record after, I
In
didn't
that
take it down. No, if
Okay.
there was one, it may have been included like from the PD with the discovery materials, like all in that.
Gotcha, okay. Okay, you can bring the jury in. And what I'll do is ask, we'll take maybe an extended lunch break and for y'all's cooperation to help maybe, so that we're not delayed, get, whatever we need to do to get somebody here, would be great. Do you have a name?
For the custodian of record.
Yes.
Let's see here.
Judge, I will say this, I put Mr. Cooper on our witness list a long time ago. And he's mentioning the discovery records about his involvement in this case, discovery material, defense counsel had, it's not surprise for him to know, particularly after yesterday, seeing him here, to know that we would be calling him as a witness and that 911 call would be relevant.
I don't disagree with that.
I have the business records affidavit associated with it. I just need the ability to print it.
Well, Judge.
Let's get there when we get there. You can bring the jury in.
The whole way that business record affidavit works is if it's on file for 14 days in advance. That's not supposed to.
So
Hold on. All right, let the record reflect the jury is seated, state's attorneys present, defendant and defense counsel are present. Mr. Coleman, at this time, does the state have any rebuttal?
Yes, Judge, state called Daryl Cooper.
All right, Daryl Cooper.
Daryl Cooper.
And was Mr. Cooper here yesterday?
Yes, he was.
First sworn, thank you. Good morning, you can have a seat right over there in that chair, Mr. Cooper. And if you'll pull that microphone down right there as close as you can get it, make sure you speak loudly and clearly so everyone can hear you. Also, Mr. Cooper, if it's a yes or a no question that's asked to you, please say yes or no and not just a head nod or a so the court reporter can get everything down.
Yes.
Thank you. And you are under oath still from yesterday as well, correct?
Yes.
All right, you may proceed.
Good morning, Mr. Cooper. Would you please state your full name for the court reporter?
Harold Wayne Cooper Senior.
And Mr. Cooper, how old of an individual are you, sir?
I'm 65.
And I saw that you kind of had some difficulty making your way into the courtroom. What do you have going on with your foot? Is it your foot?
I'm disabled. I have no control over my left leg. I had surgery yesterday on my foot.
All right, thank you. Thank you for being here today. In fact, speaking of being here today, you didn't want to be here today, did you?
No idea.
In fact, it was with we had to make some efforts to get you here. Is that fair to say?
objection.
Overruled.
Well,
I'll
no,
move on. I'll move on, Judge. I want to take you back to September the 7th, 2024. What did you tell law enforcement happened on that day?
law enforcement paid. Wow. At the Heritage,
Heritage.
yes, motel.
Heritage is a hotel, a motel?
It's a hotel.
Okay, on 11th Street,
Yes,
here in Beaumont.
right.
Okay, go on, please.
Yes. The day before, the incident happened, I was in a room. And after receiving the car to the room, I entered the room and had whiskey while cigarettes. And so I went back downstairs and I told them that the room had been cigarettes. It has whiskey bottles and cigarettes.
Let's do this. I want to get straight to what we are here for. Did you encounter Romeo Johnson on
This
that
is
day?
why this is when I encountered
Okay,
when I went back down to get my resume out of the car.
yes, sir.
Mr. Romeo was at the door. I said, I have to go to the room. And he said, well, you come on in. So no, I went back downstairs. And I told the individual was at the room itself. And she gave me another key. So the next day, I went to go get another room. Mr. Romeo said, who, let me holler at you. And I said, I just got off work on medical. So he stopped me and
I gotta keep it question and answer. Let me ask you this
Okay.
question. Was when he encountered you encountered him the next day, was he alone? Or
no,
was
he was with he was with another individual too.
And what did he and that other individual make you do at that point?
The first of asked me for money
Mm-hmm.
because they were using the room and they banded them from the motel.
Okay, and he asked you, the two of them asked you for money, and what was your response?
I said, no, I don't have any money on me. I had money, but
I'm trying to keep it moving, Mr.
I understand that, but you have to understand when you ask me a question, I'm trying to give you the answer.
Fair enough, Mr. Cooper.
Okay.
Please go right ahead, sir.
Okay. So I told him that I didn't have the money. I said, man, you got us put out to property. So, you're gonna pay us. I had money. But he had said, no, he go to me to the side Sarah and the other guy with her. They said, come on, you gonna give us some money. So I showed him my wallet. I had my money in my pocket. And I said, all I got is my credit cards. So
And it's someone, and I get it, Mr. Cooper. There's rules I gotta follow. I'm sorry, I know it's
I understand that.
because this defense can object if I just let you talk. The judge is gonna probably tell me, hey, you just can't let him talk.
But
It's
you don't want to answer.
Hold on, we're gonna get there. Just,
there are rules. I gotta follow.
Okay,
ask him
okay.
the question.
Did the two of them force you or make you go somewhere to another location?
They did.
Yes, sir. And that location was it a Market Basket food store?
It was that some place had ATM.
Yes, sir. And they wanted you to do what at that ATM?
They wanted me to withdraw money out of my account
Now, did you willingly want to do that?
willingly.
Yes, sir. Was it your idea to do that?
Yes, it was my idea to go to Market Basket because they got cameras there.
Okay, but you didn't want to give him money is what I'm getting at, right?
Of course not.
All right. And what, if any, item did you see or observe on Romeo Johnson during the process of them attempting to get you to withdraw money from the ATM?
But they forced me to go there.
Yes, sir.
And they said don't run. Don't run. You're going down. So the other guy said, Roma asked the other guy something because I was in front. And the other guy said, I got to go back and get something, get mine. So he said, well, give me yours. And I kind of looked at him, said, man, I look back here. He said, keep going. So after getting
Hold on.
What did Romeo have on?
what did Romeo have on?
Did you see him with a weapon?
Of course.
All right, that's what I'm getting at. This
Okay.
jury wasn't there, so they need to understand.
Oh,
what
well,
you saw.
okay.
What did you see on Romeo?
He had a pistol. It clicked. While I was in front.
This is while he was attempting to get you to withdraw money from the ATM.
This was while we were going to Market Basket.
Yes. Did you in fact withdraw money from the ATM?
I'm a little bit smarter than that, sir.
Okay,
Yeah,
what did you do then?
I pushed the pin in, the wrong pin in 3 times.
Oh, very good. So you intentionally entered the wrong PIN number. So then what happened?
After the 3rd time, it locks.
Okay. And what did you do next?
They asked me for my card,
Okay,
so they could try it.
okay, and then what happened?
I let them use it because it got cameras in it.
Okay,
Yeah.
and were they successful?
Nope, the card was locked.
Did you or they purchase any items with the card?
The card was locked.
Oh, I get that. If you told law enforcement that they made you buy like candy or something, is that the case?
The card was locked. But I did not do the matter of fact, the manager, we went to to the counter.
Yes, sir.
They said, well, you go to the counter and trust, you know what I mean?
Uh-huh.
And I knew the manager. I'm looking at the manager, and he know I come there every day because I was saying it for over 2 months.
Let me ask you this. Did you tell law enforcement that they made you buy 2 drinks in the candy bar and ask you to get cash back? Did you tell law enforcement that?
That's what they asked me to do.
But what really happened? What happened?
The card was locked, sir. I
got it.
intentionally locked the card.
Okay. Yes, sir. And ultimately, did they take your wallet from you?
They did it, Dad. They did. I stopped. Matter of fact, they told me, come on. So I know they got camera right at the front door.
Yes.
So I stopped intentionally at the front door and told them no. So one got on one side, one got on the other side of me, you know what I mean?
Mhm.
And I'm looking at the manager, the cash person is right in front of the door, front door.
Yes, sir.
Now, the manager see me struggling with the guy, you know, natural something, okay, it's on camera, the manager see it, okay, they gonna go.
But
They did not, they drugged me in the parking lot.
but ultimately they took your wallet, right?
I did say that.
I'm sorry. I just want to be clear.
I did say that.
Yes or no, Mr. Cooper?
Yes.
They took your wallet,
They did.
and your wallet contained your debit card and some amount of cash,
Yeah,
right?
though it didn't have cash. I had cash in my pocket.
But your wallet contained some items, including your debit card, right?
Everything.
All right. I'll pass the witness check. Thank you. Oh, one final question. I'm sorry.
Matter of fact,
Do you see?
matter of fact,
Hang on,
Hold
hang
on,
on.
Do you see Romeo Johnson in the courtroom here today?
of course,
Could you please point to him and identify him by the article of clothing that he's
he
wearing?
has on a green shirt. You know, he's to my right.
Yes, sir. I'd ask the record reflect the witness has identified the defendant, Judge.
The record will so reflect.
I'll pass the witness check.
Mr. Cooper, did you speak with the 911 operator regarding this incident?
I don't remember at this time. Yeah, it's been a minute. And I was shocked. I told her, yes,
So you did speak with 911 operator,
yeah,
and did you tell the 911 operator that there wasn't a firearm involved?
there was a what?
That there was not a firearm involved?
Why would I say that? No, I didn't tell her that.
You don't remember saying that?
I don't remember saying that.
If you were to listen to that call, would that help refresh
It
your
probably would.
recollection?
Sir, I was in shock at the point. Yeah.
If you listened to that call, would it refresh your recollection about what you said that evening?
Probably would. I mean, at the time, I knew Romeo. The other guy had told me that.
Objection to
Yeah.
the non-responsive portion, Your Honor.
Sustained. Just be sure and answer the question that he's asked, okay?
You never told officers that Mr. Johnson had a gun, did you? Or a firearm, did you?
They did have a firearm.
You
Obviously. I mean, sir.
Objection, non-responsive.
Just be sure to answer the question. Yeah,
Okay.
You never told officers that Romeo Johnson had a gun, did you?
I don't recall because I know the other guy did.
You said you know the other guy did.
Yeah.
You mean somebody else with Mr. Johnson?
Of course.
And didn't you say that, that individual, put his hand inside a bag?
Yeah.
Yeah, and said, give me your money or I'm gonna do you,
Right.
right? With a hand inside a bag, right?
Right.
Right. Romeo Johnson didn't say that to you, did he?
He was with him.
He was with him. Okay, and so when you.
But he
Hold
had.
on, hold on.
Okay.
Just answer the question.
When you say that Romeo Johnson had a gun, you never saw a gun on Mr. Johnson, did you?
Yes, he did.
When?
When he handed him the gun, the other guy handed him the gun and said he had to go back to the motel to get something.
The other guy handed Romeo the gun?
Yeah.
When was this?
On the way, taking me to the market basket.
On the way. I just asked you, did Romeo Johnson have a gun at the market basket, right? Romeo Johnson didn't threaten you with a gun, did he?
Yes, he did.
He threatened you where?
Going to the market basket.
Going to market basket.
Right.
This defendant threatened you with a gun.
Right. He said, "Don't run."
Don't run.
That's right. He said, "Don't run. You're going down."
Isn't it true that you had borrowed $300 from Mr. Bello?
From who?
Bello?
No.
No? I'm sorry?
No.
No? Oh, why were you being asked for money?
Well, because reason being, this is where they were staying at.
Mm-hmm.
At the Heritage Motel.
Yeah.
When you get before you check out, the maids open the door and you can allow them to clean the room.
Mm-hmm.
Okay, after 11 o'clock, all you have to do is just turn the deadbolt, and the door doesn't lock. So you can use that room that whole day until that next day, as long as you don't close the deadbolt light and leave out.
Okay.
When you leave out that room, you can get before you leave out that room, you snap the deadbolt lock. The door doesn't close.
The
That-
911 operator specifically asked you if a firearm was involved, didn't they?
I don't remember. That's been years ago.
Would it help refresh your recollection to listen to the call?
Yeah, it would help.
Your Honor, approach the witness. I don't know if you want to temporarily excuse the jury.
Yeah, we're not, but we can't play it here. Let's do this, ladies and gentlemen. It's 10 minutes to 12. Let's go ahead and would like to get started at 1:15. Please keep in mind all the instructions you were previously given. If everyone else would remain seated, you're excused until 1:15. All right, let the record reflect the jury's outside the presence of the courtroom. So what we'll do is take our lunch break before we leave. To do that, you can visit with the Mr. Cooper, play whatever portion of that recording you want to, and then Mr. Cooper, you'll need to come back and finish your testimony after lunch at 1:15, okay? And then we'll get you out of here hopefully as quickly as we can after that. Okay, but y'all can visit for a little bit. We'll close court, and then also I have sent you guys a new charge that includes the two new provisions. I took out obviously the defendant testifying. I added evidence of wrongful acts. I also added evidence of prior convictions. I added those two paragraphs. So I need you guys to take a look at that as well. There will not be any delay. If you're trying to get someone here, you need to try to make that happen with regard to any additional witnesses. All right, court will be in recess till 1:15. All right, let the record reflect state's attorneys present, defendant and defense counsel are present. Anything we need to do before we bring the jury in?
Nothing said.
Judge, do you want to address the charge now or wait until after?
Let's wait till after. You can bring the jury in. And y'all all got the newest email with
Yes.
that in it. Do either of you want me to print a copy when it's time to work on it, or y'all?
No, Judge, please.
We don't technically put this court's copy in. We'll just check together. I surely need it. I think we did. That's fine. We'll do it if I did. I think we talked about it. Yeah, okay. It's not gonna hurt anything to have them. All right, let the record reflect the jury is seated, state's attorney is present, defendant and defense counsel are present. Mr. Wilkerson, you may continue.
Thank you, Your Honor. Cooper, are you the same Daryl Cooper who either does presently or used to live at a house on Pine Street?
No, I've never lived on Pine Street.
You've never lived off or off of Pine Street, right off of it?
I lived on East Gill Street.
I'm sorry,
I lived on East Gill Street.
very near the corner?
No,
No?
at the bottom of East Gill.
Okay. Before we took a lunch, I'd asked you, if you recalled making some statements. When you spoke with the 911 operator, isn't it true that you told her first that you didn't know what they had?
Yeah. At that point in time, that was seconds after I got right.
Objection on
Yeah,
response.
So just answer the questions that he's asking you, and the state will have an opportunity to follow up.
Isn't it true that you told the 911 operator you didn't know what they had had?
I don't recall.
So, Mr. Cooper, you listened to that recording with Mr. Wilkerson over the break,
Okay.
correct?
Okay, right.
So you were able to reflect your memory about what you did or didn't say on that recording, correct?
I did, yes.
Okay, so just answer the questions based on what he's asking you. And again, if there's any explanation, Mr. Coleman will be able to ask you about any follow-up, okay?
Okay.
All right.
You've told the 911 operator that you didn't know what they had, didn't you?
That's what I said on the thing.
Okay, and you had the wherewithal to tell the operator that the individual who was not Mr. Johnson, put his, or had a bag that he pointed at you with, right?
Right, big picture.
And you were also, you testified that you were drugged. You were also asked if you needed EMS attention, right?
Right,
Which you ultimately refused, right?
right.
And y'all spent, would it be fair to say you spent more than 2 minutes on the phone together
With
with the 911 operator?
maybe, I didn't have my watch on.
Well, I'm asking because I understand you to be attempting to assert that you were still in some kind of shock or trauma associated with this interaction, right? That you couldn't think to tell the 911 operator that there were firearms or that there were weapons involved, right? That's what you're saying?
Well, I knew the police were coming. That was is the police officer here? Cause he written down everything I told him.
All right. Mr. Cooper. Oh, hang on. let me trace it. Mr. Cooper, you were convicted in 2024 for theft of property, a state jail felony, correct?
Yes, yes,
And that conviction included the fact that you had 2 or more prior theft convictions, right?
Right.
And that's why it was a felony, correct?
Yes.
Alright. In conjunction with, the, that case being adjudicated, a separate, criminal mischief, also felony, was dismissed, correct?
What's this have to do with Mr. Roman?
Ask the witness be instructed to answer.
Judge, I would object to that because that's not proper impeachment. That type of an offense is not proper impeachment.
Sustained.
In 2019, you were convicted of a Class B theft, correct?
I guess, so.
And in 2018, you were convicted of a Class B theft, correct?
Okay, yes.
And going back to 2000 and in 2010, you were convicted of a felony offense, correct?
Am I being charged again with it?
Ask the witness.
Sir, just answer the question.
Yes.
And then just prior to that, in 2007, you were convicted of the misdemeanor of burglary of a coin-operated machine, correct?
Right.
Isn't it true that you and Mr. Johnson, for a number of years hung out together?
I've known him.
You've known him? Has he spent time at your house?
A lot comes to my mind.
I asked the witness be instructed to answer the question.
Answer the question.
Sir, I'm 65 years old, and that house was given to me when I was 27, 37. So I don't recall that when it came out my home.
You don't know if the defendant ever came to your home.
Really, I don't.
Well, let me ask you this, in terms of the defendant coming to your home, would he have reason to come and hang out there?
Sir, as I said, I don't remember who all came by my home.
What I'm asking you, sir, is there some purpose for which he would have came and hung out there?
I would object to the relevance of.
I suppose the same thing over the road.
Hold on.
I object to the relevance of any prior visits to this residence house.
Well, he said he doesn't recall anyways. It's been asked and answered.
You were asked earlier if you had wanted to be here. A writ of attachment had to be issued to get you here, didn't it?
Not good, sir. You have to understand with me. I work. I had my leg amputated.
Objection.
You asked me a question. Can I answer, ma'am?
Well, you're not answering really the question he asked. So he asked,
The reason being why, because I got robbed.
Hold on.
Yeah.
You have to answer just the questions he's
Okay.
asking you. I know you want to explain more, but that's not really the way it works, okay?
Okay.
Thank you, sir.
And back when you alleged that the defendant robbed you, was your foot broken at that time?
My foot was never broke, but I got hit by 18-wheeler. I was dropped, but have no control over when I walk out to beside conservative where I'm going. When I walk, maybe right step, turn for left step.
When did that happen?
May 26th of 80. I'm disabled.
And it's your testimony that you never borrowed any money from the individual who was with Mr. Johnson?
Absolutely not. Absolutely not. I have money. I work every day. I have cash every day. That's why I got robbed.
Okay, why were you staying at the hotel?
Objection, relevance.
Your Honor, I believe that this will explain what was going on that led to the exchange between that led to the allegations that the witness is making that this defendant robbed him.
Overruled. You can answer the question.
Was I staying at the hotel?
Yes,
Because I was homeless.
you don't still own the house that you were given years ago?
Of course not.
So you were staying there long term?
There's, whether you're short term or long term, I don't see the relevance.
Sustained at this time.
Is um is that particular location a location that where a lot of illicit substances are trafficked?
Objection, relevance to this defendant and the allegations.
Sustained.
This witness subject said.
Pass witness.
Thank you. Anything else, Mr. Coleman?
Just a couple of follow-ups if I may, Judge. Ms. Cooper, you made reference to a clicking sound within that bag that you believe there to be a firearm.
Yes.
And when you say click, are we talking about maybe possible racking of a firearm?
Yes.
Okay. Do you have any doubt whether or not this defendant was acting in concert with or together with the other individual when they took you to the ATM to try to get you to force you to withdraw money?
Of course, before and after.
Okay. And regardless of your criminal history or your run-ins with the law, are you here today and telling this jury the truth about what happened that day?
Yeah, 100%.
Thank you, Mr. Cooper. I'll press the witness, Judge.
Anything else, Mr. Wilkerson?
Yes, Your Honor. You testified that y'all walked to the market basket that night, correct?
Correct.
All right. Did your injury interfere with that walk?
My injury with the injury you speak on the for my leg,
Yes.
did it interfere? I walk every day. No, it has no, it didn't. No, did
Okay. So what you're telling this jury right now and here today is that despite all of your other dishonesty in the past, you want this jury to believe that this man robbed you despite you being homeless at the time?
where'd you get that from?
You said you were staying at the hotel because
Okay, that has no relevance, but I told you that you wouldn't let me take. This is why he was upset because they banded him from the property and he could no longer stay there. So he figured that I owe him for him not being able to be there anymore.
Mr. Cooper.
Yeah, that's the truth.
Okay, I understand. Just listen to the questions and answer them, please.
Asked the jury be instructed to disregard.
Judge, he asked the question. He opened it.
I'm not gonna, no.
And so again, you're asking this jury to believe that this defendant robbed a homeless man.
Of course.
And if you were homeless, what belief or reason to believe that you had money that the defendant had?
Because I work every
Let's
day.
say, Judge, Judge, this is part of speculation. On part of this witness as to what this defendant believed.
This witness testified that this defendant knew that he could get money.
Of course, I work every day. I do hit like research. I have cash on me every day. That's how I was staying at the hotel. They don't let me stay there free.
Objections, non-responsive.
I think he's answering the question.
Was someone else staying with you there?
No,
You weren't sharing a room with another lady?
maybe sometimes I get like it. That you trying to mislead the jury. Look, you asked me a question. I told you. I answered it.
But I want you to answer honestly.
And if you ask me each question separately, I would.
That's the witness.
I have no further questions for Mr. Cooper.
Any objection to
He-
Mr.
he-
Cooper being excused?
No, Judge.
No objection. no.
Thank you, Mr. Cooper. You're excused. Keep in mind those instructions you were given yesterday also, okay?
The state has no further rebuttal. Your Honor.
Thank you, Mr. Coleman. Mr. Wilkerson, any rebuttal? You've heard all the evidence that'll be presented in the trial. The next thing is for me to read that court's charge to you. I've prepared it just based on, we need to take a break based on the testimony, make sure we have it all the way it's supposed to be. This shouldn't take longer than 10 or 15 minutes because it's already done. So it's 1:35. I'd like to try to get started about 10 till 2. Please keep in mind all the instructions you were previously given. If everyone else would please remain seated, you are excused for about 15 or 20 minutes. That's the part of it. Got too much going on over here. Mr. Wilkerson. Yes, sir. All right, let the record reflect the jury's outside the presence of the courtroom. You guys are both given a copy of the court's proposed charge. Any requested additions, objections, or corrections that you guys found?
No from the state, Judge.
Yes, Your Honor, with regard to the paragraph under evidence of wrongful acts possibly committed by the defendant.
What page are we on?
Page 3, Your Honor.
Thank you.
First paragraph under that heading references the murder charge and then says you are not to consider that evidence at all unless you find beyond a reasonable doubt that the defendant did in fact commit the wrongful act. I believe they have to be instructed that they cannot consider that in terms of because he has been acquitted of the matter. If they're going to receive an instruction regarding the murder.
Just because he was acquitted doesn't mean they can't consider it,
If it was,
right? I mean,
if he was acquitted, then to consider it as a wrongful act would be antithetical to the acquittal, Your Honor.
Judge, I conferred with Mr. Smith about that over at the break. It stuck out to me too.
Okay.
One of the things I considered was maybe saying the state offered the evidence to show that the defendant either possessed a firearm or to show the links between a firearm and the defendant. I considered that kind of language maybe, out of an abundance of caution.
so what's your thoughts then, Mr. Wilkerson, on, I mean, are you asking that I just take it out completely? Because I don't think I want to take it out completely because I think they need to be instructed about something with regard to that offense, right?
I would not disagree with the court, Your Honor, in that statement. But in terms of,
So what if I change it to,
Technically, there was no evidence put on about the murder itself.
I know.
It was in relation to him possessing a firearm in previous time.
so,
Not only previous time, but contemporaneous.
well, I can do, a lot of times we don't even include the specific other act. So some defense attorneys ask for it, some don't. Sometimes we'll leave that sentence out and just say,
So just
you heard evidence that the defendant may have committed wrongful acts not charged in the indictment. And then take out the next sentence.
Yes.
And then put, you are not to consider that evidence at all unless you find beyond a reasonable doubt. And so you're not pinpointing the murder because there was evidence of the aggravated robbery with Mr. Cooper. And I didn't specifically put that in there yet. So if we're going to do one, we need to do both. So it's probably, I would think, better to put none. But what does that help clear up what you're?
I think it does, Your Honor, because I think they implicitly understand that he was acquitted. I think perhaps the mentioning of if you did want to put something in there, such as Mr. Coleman suggested, mentioning of lack of mistake, maybe. I'm not sure what the state cites in terms of that. Those reasons for which that evidence can be considered.
Well, it's a little bit different, I guess, because technically you brought it in first. And so the state really didn't offer it to show anything. And so because of that, I don't know that it would be, I don't even know that, I mean, I don't mind leaving that. The state offered the evidence because they went further into that evidence to show once that door was open. But I didn't allow them to go into that evidence, or it was specifically the murder. And it wouldn't have been the aggravated robbery charge either. So both of those really kind of came in.
And I think I think then the court's idea of
Just
just
taking the ones.
removing that sentence altogether
Okay.
would probably be the best way to.
I've done that. Was there anything else?
Your Honor, we had requests, well, we had we had previously requested, we had informed the court of our intent to request an instruction on voluntariness of the, for what, lack of a better term, the alleged confession.
So I think because Mr. Johnson again took the stand in this case, you specifically questioned him in this case about his taking the stand in the prior murder after advice from you, that I don't know that there's any issue with voluntariness. I understand that your position that he wasn't being questioned specifically, it was a murder case and not the other, but the murder case, by the nature of the murder case, had to do with the weapon. And so did the actual video and everything that came in that everybody knew about in that trial. So I'm not going to put an instruction in on that. I have also already for appellate purposes, if necessary, put in court's exhibit number 1, which does show that admonishment that you and I both talked to Mr. Johnson about in that prior case. So that's in the record for appellate purposes only.
And otherwise, Judge, nothing else from the defense.
All right, so I took that one sentence out. Let me, do either of you want me to print a final copy for you?
No.
Just with that one sentence out? Okay.
No.
Print one for myself will be, we have about 5 minutes if anybody needs a quick break. All right, we're back on the record. State's attorney's present, defendant and defense counsel are present. How long would you request for closing?
10 minutes on the high side.
Mr. Wilkerson? 15?
I hopefully, yes.
15. Okay. All right, you can bring the jury back in. All right, let the record reflect the jury is seated, state's attorneys present, defendant, defense counsel are present. At this time, ladies and gentlemen, I am required to read the jury charge to you in full. And so pay attention and then you will hear from the closing argument from counsel. Cause number 25, DCCR 1626, the state of Texas versus Romeo R. Johnson, aka Romeo Randolph Johnson. Members of the jury, the defendant, Romeo R. Johnson, aka Romeo Randolph Johnson, stands charged by indictment with unlawful possession of a firearm by a felon. The defendant has pleaded not guilty, and you have heard all the evidence. The parties will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether or not the state has proved the defendant guilty. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable to this case. General principles. The indictment is not evidence of guilt. The indictment is a document required to bring the case before you. Do not consider the fact that the defendant has been arrested, confined, or indicted or otherwise charged. Do not draw any inference of guilt from any of these circumstances. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless the state proves each element of the offense beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient for you to return a verdict of not guilty. You may find the defendant guilty only after a careful and impartial consideration of all the evidence, and only if the state has proved the defendant's guilt beyond a reasonable doubt. The state has the burden to prove every element of the offense beyond a reasonable doubt. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If it does not, then you must find the defendant not guilty. If, after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms, the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request that testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement or of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in dispute. The law requires that you render a verdict of either guilty or not guilty. The verdict of not guilty simply means that the state has not proved the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. Evidence of wrongful acts possibly committed by the defendant. During the trial, you heard evidence that the defendant may have committed wrongful acts not charged in the indictment. You are not to consider that evidence at all unless you find beyond a reasonable doubt that the defendant did in fact commit the wrongful act. Those who believe the defendant did the wrongful act may consider it. Even if you do find that the defendant committed a wrongful act, you may consider this evidence only for the limited purpose I have described. You may not consider this evidence to prove that the defendant is a bad person and for this reason was likely to commit the charged offense. In other words, you should consider this evidence only for the specific limited purpose I have described. To consider this evidence for any other purpose would be improper. Evidence of prior convictions of defendant. Evidence that the defendant was previously convicted of an offense can be considered only for the limited purpose of determining if you believe the defendant. Even though evidence was introduced that the defendant was previously convicted of an offense or offenses, you must not consider it as evidence of guilt in this case. You may choose to disregard the evidence and not consider it at all. But if you choose to consider the evidence, you must consider it only for the limited purpose of determining if you believe the defendant and the weight to give his testimony. Rules that control deliberations. You must follow these rules while you're deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to select your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. 3, you must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments. 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the state has proved the defendant guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use the form attached to these instructions. The foreperson should sign the line that corresponds to your verdict. After the closing arguments by attorneys, you will begin your deliberations to decide your verdict. Law specific to this case. The state accuses the defendant of having committed the offense of possession of a firearm while having been previously convicted of a felony offense. Relevant statute. A person commits the offense of possession of a firearm while having been previously convicted of a felony offense if he intentionally, knowingly, or recklessly possesses a firearm and at the time of the offense, the person had been convicted of a felony offense and the person possessed the firearm before the 5th anniversary of the date of the person's release from confinement following conviction of the felony offense. Definitions. A firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. Possession means actual care, custody, control, or management. A person intentionally possesses a firearm if the person has the conscious objective or desire to possess the firearm. A person knowingly possesses a firearm if the person is aware that he is possessing a firearm. A person recklessly possesses a firearm if the person is aware of the substantial and unjustifiable risk that he is possessing a firearm, but consciously disregards that risk, and the risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the person's standpoint. Application of law to the facts. You must determine whether the state has proved beyond a reasonable doubt 5 elements. The elements are that 1, the defendant in Jefferson County, Texas, on or about September 14th, 2024, excuse me, possessed a firearm. 2, the defendant did this intentionally, knowingly, or recklessly. 3, at the time of the possession of the firearm, the defendant had been convicted of the felony offense of evading arrest or detention with previous convictions on April 13th, 2022, in cause number 20-34416 in the Criminal District Court in Jefferson County, Texas. 4, at the time of the possession of the firearm, the defendant knew that or was reckless about whether he had been convicted of a felony offense. And 5, the defendant possessed the firearm before the 5th anniversary of the defendant's release from confinement following the conviction of the felony offense. You must all agree on the elements 1 through 5 listed above. If you all agree that the state has failed to prove beyond a reasonable doubt any one of elements 1 through 5 listed above, you must find the defendant not guilty. If you all agree that the state has proved beyond a reasonable doubt all 5 of the elements listed above, you must find the defendant guilty. And then that has my signature, and then the last page is the verdict form. The top is titled Verdict Not Guilty. We, the jury, find the defendant Romeo R. Johnson, aka Romeo Randolph Johnson, not guilty. And then there's a space for the signature and the printed name of the foreperson. And then below that is titled Verdict Guilty. We, the jury, find the defendant Romeo R. Johnson, aka Romeo Randolph Johnson, guilty of unlawful possession of a firearm by felon as charged in the indictment. And again, there's a line for the signature and the printed name of the foreperson. Mr. Coleman, the state has the right to open and closing arguments.
On the time, at this time, the state waives its right to open, but reserves its right to close.
All right, thank you, Mr. Coleman. Mr. Wilkerson, you may proceed.
Thank you, John. Please, court.
Yes, sir.
Ladies and gentlemen of the jury, I want to thank you again for sitting through all of this. I told you at the beginning that I didn't believe this case was as straightforward as state's attorney told you. I outlined, and the state's attorney as well outlined some of the evidence that you would see in this case. And so let's talk about that for a minute. So you have a video and some photographs that are unclear and can't see what's actually being held. You have testimony from a defendant given in a murder trial where both there and here, he has been 100% real with the jury. He's told y'all about the things that he's done wrong in his life. He's told y'all about the street life. He's told y'all about what the behaviors he used to be engaged in. He's been real with it. Meanwhile, the state wants to put on a person by the name of Derek Cooper to essentially say, oh no, he robbed me with a firearm. And then Mr. Cooper says that the defendant knew he always had money, right? Because he worked, etc. Well, that's an awful lot of theft for someone who always has money. And I can't imagine not knowing people came to my house. I just really can't. That is not a world experience that I can relate to. And I don't believe it is relatable unless people are coming when you're out of your mind. I just don't. And I don't think you should either. So let's look at the sequence of events and what happened. The defendant took the stand, as you heard, against the advice of counsel in a prior trial, where he was on trial for one of the most serious offenses you can be charged with, right? Indicted for, convicted of even. He was fighting for his liberty, his entire future. So he took the stand and he told the truth. He told the truth then, he's told you the truth now. Now, the state wants you to believe that since the defendant never said, well, the gun wasn't a BB gun, it wasn't a replica, it wasn't an airsoft gun, that the defendant essentially is letting the state believe that it's a firearm. But what they don't want you to think about is that both the detective, as the detective told you, and the state at that hearing both had the opportunity to clarify whether or not that gun was indeed a firearm. We can't tell, we can't see it. I mean, I see something gray in Ethan Smith's hand. And what about Ethan Smith? Why wasn't he here to tell you exactly what it was that he gave the defendant, if it was indeed a firearm? Why not? You, in your charge, the term firearm is defined specifically for you, right? And as much as the detective, or I'm sorry, Officer Carmouche would want you um, to believe that the colloquialism gun always applies to a firearm, that we simply know is not always the case, right? And we know that toys, we know that airsoft guns, for instance, are looking more and more real. You know, that's why the law doesn't even require you actually have a firearm for an aggravated robbery or an aggravated assault. All you have to do is make somebody believe you do. Maybe you could do that with a toy. You can do that with your hand. And despite the state's prior opportunities, they didn't do it. Ladies and gentlemen, it is not the defense's job to disprove the state's case. It is the state's job to prove their case to you beyond a reasonable doubt. You know, in voir dire, we talked specifically about the example of a firearm in terms of the puzzle pieces. Y'all remember I asked y'all about it, and I asked you about that piece that if at the end of it, you put it in the puzzle and that little tip is orange, it changes the picture entirely. Well, ladies and gentlemen, you certainly have more of the story or more of the context than I expected you to have, but you still don't have all the pieces. And you don't have all the pieces because the state has not given them to you. The defendant doesn't have to call a witness to say, oh no, that wasn't a firearm. The state, knowing who the person in the video was, the state, the officer, detective at the time investigating the underlying case, talking to Ethan Smith. But he's not here to tell you that, yeah, he gave this defendant a firearm on that night. And ladies and gentlemen, the only way that you can prevent the state from serially indicting cases is to find this defendant not guilty. You know, when we often say in terms of law school that the guilty stand in place of the innocent, right? Because if the government can execute an invalid search warrant on a guilty person, they can do it on an innocent person as well. And for those reasons, certain policies, procedures, rules, and laws must be followed. In this case, you have the opportunity to take a stand against, okay, well, I didn't get him on that one, so now I'm gonna immediately re-indict him on something else. A long time after the original investigation took place. There's only one way to prevent. Just like there's only one way to prevent an officer from filing a false affidavit, right, to get a search warrant, or to execute a search and seizure without a warrant, which is to exclude the evidence, right? That's what happens if those procedures are not followed properly, if evidence is seized without it being, without a warrant, or some sort of probable cause with an exception, set forth. That's the mechanism by which we hold our government to account. And those are the procedures and the mechanisms by which you need to hold the government to account here today. In terms of proof beyond a reasonable doubt, no, it's not beyond all doubt. Right? And like we talked about before, dear, we don't go around talking about, I believe by preponderance of the evidence that this happened, or I believe beyond a reasonable doubt that. But what we were able to discuss is that beyond a reasonable doubt is the highest burden of proof. And so if it were your loved one sitting in that seat, remember we talked about the burden of proof required in order to terminate the relationship between a parent and a child? And how that burden of proof is lower than the state's burden of proof here? The state wants you to make a lot of assumptions about evidence that they had the opportunity to present to you, but did not. And you have to ask yourself why. If it's sufficient to come in here and just presume that someone's guilty based on the way one situation played out, or based on things that were said that weren't clarified despite the opportunity, if it's okay to come in and say, well, we didn't get you on that, so we're going to refile and try and get you on something, okay, then it's okay for everybody. And that is the dilemma that you're faced with, right? Either presume that the phrase gun, which is not defined in law, is interchangeable with the phrase firearm, which is defined by law and defined in your charge. There are reasons that those definitions exist. Ultimately, at the end of the day, whatever your decision is, that will be justice. And I believe that, and I believe that wholeheartedly, and I'll tell you what. I believe that all 12 of you will go back there and talk about the evidence, and talk about presumptions that perhaps should be made and presumptions that should not be made. Talk about what proof really is. Right? Officer Carmouche believes it was a firearm. They want you to believe that because there was a murder later on that they alleged the defendant was near, or at one time alleged the defendant committed, but was acquitted of that offense, that means he must have had a firearm. He was acquitted. There are reasons. But what it means is the state didn't prove their case there beyond a reasonable doubt. And you've got just a glimpse of some of the evidence that was presented in that case. Finally, I want to talk to y'all just very briefly about what I call, or what I say, call it my don't go along to get along speech. When y'all are deliberating, unless a piece of evidence changes your mind, unless the discussion and there's argument about a piece of evidence that convinces you beyond a reasonable doubt, if you're not guilty, don't change to guilty just to get to go home, because I promise you it will happen. At some point, it will happen. You won't be stuck here for 6 weeks. I promise you. Now, ladies and gentlemen, today is the day. Right? We all come in here with our life experiences. But 5 years from now, 10 years from now, you don't get to be standing at your sink and think, you know, that case that I was a juror on, I wonder. Or someone you love be accused of something similar and think, wow, I saw this similar situation and I chose to convict that person. If you have a doubt, today is the day to express it, because you do not get to revisit it later. Give the defendant justice, find him not guilty as the law requires. Thank you.
Thank you, Mr. Wilkerson. Mr. Coleman?
Thank you, Honor. May it please the court, counsel, ladies and gentlemen of the jury. I want to begin by thanking you on behalf of the district attorney's office, and thank you on behalf of our community for your time and attention. This has been a brief trial, relatively brief trial, but from time to time I've looked over, and I think that you all have been engaged. I think that you all have paid very close attention to the evidence and the testimony in this case, and for that I thank you. I began my opening statement by saying that this is both a straightforward case and a serious case. Straightforward in the sense that either you believe what you saw in the video, and either you believe that the defendant's sworn testimony that he quote unquote gave the gun back to his compadre there, or you don't. It's just that simple. I'm not going to try to gloss it over. I'm not going to try to make a big production about anything. It is straightforward in that sense. Either you believe the video and you believe the defendant's own words, or you don't. It is both straightforward and serious. Serious in the sense, now that, to borrow a phrase from defense counsel, that you've seen the whole story, heard the whole story. It is serious in that sense. No doubt, no wonder why we have a situation in Jefferson County with gun violence that we do. Because this is the kind of case where it starts, okay? Arguments in the parking lot, 2 a.m. in the morning, and the next thing you know, we have an escalation. How many times have you heard a story about gun violence and you wonder, why don't they do something about it? Again, I'm borrowing a phrase from defense counsel. He said during his closing, today is the day. I'm going to say the same thing. Today is the day. Today is the day that you are they. Today is the day that you get to say, you know what, at least in this case, based on the evidence, we're going to stop this before it escalates. We're going to find this defendant guilty based on the evidence in this case before it escalates. You know, defense counsel, and I don't mean to be flippant about it, but I'm going to borrow another phrase from him. He says, the state wants you to make a lot of assumptions. No, what I don't want you to do is make assumptions. I want you to follow the jury charge that the judge gave you, and you'll get a copy of it to take to the back with you, and you can read it for yourself. In this very charge, don't take my word for it, read it yourself. It says you are permitted to draw reasonable inferences from the testimony and the evidence in this case. That's what this says. That's the law that the judge is giving you. The law says you can draw reasonable inferences. In other words, I want you to draw reasonable inferences from that video, reasonable inferences from the testimony of Officer Carmouche, reasonable inferences from the words of the defendant himself. you can infer that he possessed a gun, a firearm. You can infer that based on the testimony. You can do so by using your common sense. You do not leave your common sense at the door when you come in here to serve as a juror. And I'm asking you to draw reasonable inferences based on your common sense. Do you think this defendant was out there at 2 a.m. in that parking lot with a BB gun? I suppose it's possible. But if you look at how worked up he is on that with that towel and going after that guy, I don't know. Even if that gives you some pause, again, from this very witness stand, he said under oath, I gave that gun back. I gave the gun back. I gave the gun back. This defendant gave you the confirmation that you need to find him guilty, to find him guilty of this offense. A couple of other things I want to point out is that this jury charge tells you that you are the sole judges of the credibility of the witnesses in this case. In other words, you can believe some, none, or all of what you have heard. And when it comes to this defendant, I don't know. I'm reminded of the phrase, pick a horse, just pick a horse and ride it. I mean, at first we start out, well, there wasn't a gun. I didn't know it was a gun. I didn't get a chance to explain at the previous court proceeding. And then it went to, well, it was wrapped in a towel. I didn't know what it was. And lastly, wait a minute. I was being investigated for a murder. So I don't know. It's kind of unfair for me now because I had the gun. But I didn't know if I knew I was being investigated for the gun, I would have done something or said something different, that kind of thing. You can, again, disregard some, none, or all of a witness's testimony. And I submit to you that with regard to that whole business, you can use your common sense on giving the defendant the credibility or the weight to his testimony that you would. He told the truth. This is another thing the defense counsel said. He told the truth then. He told the truth now. I would take issue with that. I mean, here's what I remember from that first court proceeding is that the defendant said he had never been charged with a robbery. But today you heard from that stand that he admitted to at least one robbery. Doesn't sound very truthful to me. I mean, I would submit to you, use your common sense. If you were accused, arrested, either charged or pled to and served some time on a robbery, that ain't something you usually just kind of forget about. And that's not something you get on the stand. I'll submit to you under oath and say, I've never been charged with. Again, another reason to believe either some, none, or either some, none, or all, some, or none of his testimony, if that's what you choose to do. There's another definition of the charge about possession. It says it's either actual care of, custody, control, but what it doesn't say is for how long. There's no time limit. Believe you me, if there was a time limit on that in the law, the judge would have put it in the charge. If it says you got to possess it for 5 minutes, 15 minutes, for 5 hours, believe me, she should have put it in. She would have put it in there. So just keep that in mind. Possession, no matter how brief, if it was just for a little while, he possessed that firearm. Another thing about the law. You don't need the actual gun, okay? If you needed the actual firearm and you couldn't infer that it was a firearm, believe you me, it would be in this charge. The law, the judge would give you that law if it was a legal requirement, if you had to have the actual gun. What I submit to you is not unlike what we talked about during jury selection about that jigsaw puzzle, if you got enough of the pieces here, to again infer using your common sense that he possessed a firearm, I submit to you that that's enough pieces of puzzle for you to make your decision. If you know it, if you feel it, again, going back to jury selection in your head, your heart, and your gut, based on your common sense, based on the inferences, reasonable inferences you can draw from testimony, then I'm asking you to find this defendant guilty. If you feel it in your head, your heart, and your gut, based on reasonable inferences from the evidence in the testimony in this case, I'm asking you to find this defendant guilty, not because I say so, not because Detective or Officer Carmouche says so, but because it's what the evidence demands. This is the last phrase I'll borrow from defense counsel. He said that would be justice. Yes, it would be justice to find this defendant, Romeo Johnson, guilty of unlawful possession of a firearm. Because that's what he did. And that's what the evidence demands. I'm asking you to follow your oath. I'm asking you to find good. Thank you.
Thank you, Mr. Coleman. All right, ladies and gentlemen, at this time you've heard all the evidence, the court's charge and closing argument. I'm going to hand the charge to the bailiff. She will take you to the jury deliberation room where you will begin your deliberations, and court will be in recess until you reach a verdict. Ma'am, if you'll just stay there, we'll give you your instructions in just a minute. For the rest of you, you can go back with the bailiff. All right, let the record reflect that the jury seated, state's attorneys present, defendant and defense counsel are present. At this time, I'd ask the foreperson, has the jury reached a verdict?
Your Honor, we have.
And is it the unanimous decision of all of the members of the jury?
Yes, Your Honor, it is.
Thank you, sir. You can hand it to the bailiff, please. Mr. Johnson, if you'll please rise. We, the jury, find the defendant, Romeo R. Johnson, aka Romeo Randolph Johnson, guilty of unlawful possession of a firearm by a felon as charged in the indictment. It's got the signature and the printed name of the foreperson. You may be seated. Does either party wish to have the jury polled?
The state does not.
Yes, Your Honor.
So what that means, ladies and gentlemen, is I'm just going to go through and ask each one of you individually if this was your decision and your vote. And so I'm going to start on the top and go across and then come back around. So I'll start with the top. Ma'am, was this your individual verdict?
Yes.
Sir, was it yours?
Yes.
Ma'am, was it yours?
Yes.
Sir?
Yes.
Sir, was it yours? And sir?
Yes.
Ma'am, was it yours? And then we'll come down here. Sir, was this your individual verdict?
Yes.
Sir, was it yours?
Yes.
Sir, was it yours?
Yes.
And ma'am, was it yours?
Yes.
And sir, was it yours? All right, thank you very much. And what that means at this time is I will accept your verdict, and at this time find Mr. Johnson guilty of the offense of unlawful possession of a firearm by a felon. That means that the first phase of the trial is complete, and we'll move into the second phase, which is the punishment phase of the trial. And Mr. Coleman and Mr. Wilkerson, are y'all ready to proceed? Do you need just a short break?
State's ready to proceed.
Defense is ready, Your Honor.
All right, and so Mr. Coleman, if you will read the remainder of the indictment. Do you have it handy?
I do.
Okay,
Said.
it's the enhancement paragraph. He'll need to plead true or not true to that.
And the grand jurors aforesaid upon their oaths aforesaid do further present in and to said court at said term that before the commission of the primary offense, the defendant was finally convicted of the felony of robbery second degree on March 9th, 2015 in clause number 14-21127 in the criminal district court of Jefferson County, Texas, against the peace and dignity of the state.
And is that allegation true or not true?
True.
Okay, have a seat. Right. Mr. Coleman, you ready to call your first witness, or do you wish to make an opening statement?
State wages don't state.
All right, you may call your first witness.
This time before calling my witness, I'd like to offer a certified criminal history. 12 or 15.
I showed 12.
Approach. Existing.
Yes, sir.
I have to mind standards. Oh, thank you. This time, the state offers states what's been marked as states exhibits number 12, 13, and 14. I'll proffer to the court with 12 is a certified criminal history record from BPS. 13 is an individual judgment for a 2008 offense of unauthorized use of a motor vehicle. And 14 is a summary thereof of all of this. And for the record, I'm tenured to defense counsel for his inspection.
Your Honor, same objection as previously with regard to states 12, 13, and 14.
Say it again. I don't know which one what objection you're talking about.
Relevance based on establishing that these are records related to the defendant.
They're certified. It's the certified criminal history. They're redacted. version that I offered earlier, I'm happy to provide it to the court. This is just a complete version of it. Same identifier.
So based on, well, let me look at this. So based on those identifiers that were, that I previously found in the, shortened version of, which would be State's Exhibit number 12, the Department of Public Safety, which includes date of birth, it includes the picture, the thumbnail picture, that matches the date of birth. So, with regard to that judgment that I previously looked at, I don't remember what that was. Let's see. Which one? 11. So 10, which was the evading arrest conviction judgment. And then states 13. So, okay, so with regard to states 12, the objection is overruled. States 12 is admitted. It is just the complete copy of what I admitted part of earlier in the trial. What is the specific objection with regard to states 13, which is the it's a judgment?
Same objection, Your Honor.
Y'all come up for a second. What would the argument be on this one with regard to identifying factors other than unknown?
You got it.
Okay, that's what I need. And that should be on this as well.
It should be on the certified. And so maybe tweak it back and have it. I'm having to look through it completely.
So, okay, with regard to states 13, it also has the state ID number, which is TX 07111416, which matches the DPS certified criminal record history. On the front page of that, it shows Texas DPS 07111416. Again, in that document, which is Exhibit 12, it has the picture identifying Mr. Johnson that I can myself look at and identify Mr. Johnson here in court. He's also been identified by other parties in the trial. So for that reason, states 13 is admitted, that is overruled. Now, with regard to,
Approach briefly,
okay.
Identify. Not how I. You should see the date of birth and I compare the date of birth with date of birth there.
Yeah, I don't think anything about that is commenting.
Or he can argue with the jury. Information. You're gonna have his own power.
I mean, if anything, it might go to the white up and you can show it. And if they don't believe it, they don't have to believe it. That's their, but I'm going to allow states 13 based on my the evidence that's being put forward for me with regard to identification, which is what's necessary. And then with regard to 14.
I'm offering that as a summary, Judge. Rather than going through each individual instance or event, I want to offer that to summarize those exhibits.
And what is the objection to states 14?
Your Honor, based on the prior rulings, the court withdraw the objection.
Okay, it's admitted then. Right. And if you'll remove those stickies, please.
Yes, ma'am. Your Honor, also, I'm doing this before I forget.
I'm sorry.
Let me take this off before I forget. I have another exhibit,
Okay,
but I want to do this because I don't want to forget.
thank you.
I have also marked as state's exhibit number 15, and it may be a little duplicative, but we have our reason for doing it. It's also, while it's contained in the certified criminal history record, it's also a standalone judgment for the robbery that is mentioned as an enhancement in the indictment as well. I want to offer the actual judgment for that. And I've marked it as state's 15, and for the record, I'm tendering the defense counsel. It's a certified copy.
Judge, with regard to the exhibit, same objection as previously for preservation purposes. However, in addition, we object to the what appears to be the docket or a docket attached to the judgment.
I would agree, that it should, if I'm going to allow it, unless there's some identifying factors that would be necessary on any other pages, that just the judgment document itself, not the docket sheet and anything like that.
There is a thumbprint on the docket sheet, but however, we're
Well,
not.
I don't want to get that, unless you're gonna have an investigator come. So what was the answer?
Oh, no, we're not opposed to removing the docket sheet, Your Honor.
And then, of course, there's, well,
Or any of this other.
So why don't you remove everything that's
You-
at least under that objection, that's objectionable? And then I'll take a look at it with regard to,
Okay. I'm gonna remark it since I put the label on it. I'm stay off of state 15 with the pages taken out by certain pages removed by defense counsel.
so the objection then is with regard to identity.
yes, Ron.
So I've got an indictment and a judgment.
Yes, it comprises the new exhibit judgment.
So with regard to the indictment being included in it, you don't have an objection to that if I allow it in,
If you allow it in, I don't have an objection
to that part of it. Can I see the,
Sure, Dr. Commissioner.
yeah, either 12 or 10. So with regard to state's exhibit number 15, the state identification number is the same at 07111-416. Style the same, Romeo Randolph Johnson. The Date of birth. It's not the same on this indictment. It's off by 1 day. But the judgment itself. I guess, y'all come up here for a second.
These proceedings that I could not locate copies of the jail calls. Mr. Coleman responded that somebody at my office signed for them on January 30th. But I don't know where they are. So I need an opportunity to,
For clarification purposes, Judge, he emailed me, was it yesterday or the day before yesterday?
no, it was, I believe it was last week.
Here's what I did. I responded to his email. I think it was no more than 2 days ago. And I told him specifically who signed for it because I've got a copy of it. Nikki Neal, who represented that she was from his office, signed for it on January the 30th of 2026.
And so,
And I have a copy here, need be.
um.
All right, we're gonna need to go forward. If that was signed for, I'm not, whatever happened, happened. So. Let's get the jury back in, please.
Yes,
Oh, this is.
she has
I'm
the
gonna
right
cross this out.
15.
Yeah, you got the right.
Yeah, she has the right 15.
I'll cross this out.
That's the indictment that.
Remember that 16?
Jury.
All right, let the record reflect the jury seated, state's attorneys present, defendant and defense counsel are present. Mr. Coleman,
The state calls Captain Michael Ponder.
Captain Ponder. And for the record, since the jury's in, states 15 was admitted, I think, while they were gone. Good afternoon, sir. Could you please raise your right hand? Do you swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth? Thank you, sir. You can have a seat. You may proceed.
Thank you, Your Honor. Would you please state your full name for the record, please?
My name is Captain Michael Bonner.
And Captain Ponder, how are you employed, sir?
I am the custodian of records at the Jefferson County Correctional Facility.
And that's what we refer to as the jail, Jefferson County Jail, right?
Yes, sir.
And the jail is equipped or outfitted with recording equipment that is capable of recording phone calls made from the jail by inmates.
Yes, sir.
And these inmates, are they assigned or given a unique inmate number or inmate PIN number that they use to make those jail phone calls?
Yes, sir.
And how long have you been with the jail?
11 years.
And in those 11 years, have you known that recording equipment to be reliable equipment?
Yes.
capable of making an accurate report.
Yes,
Uh, And did you listen to certain recordings associated with the PIN number for a Romeo Randolph Johnson?
yes,
May I approach the witness?
Yes, sir.
And what I'm going to mark as State's Exhibit number 16, I'll hand to you here. Before I mark it, I'll ask you if you recognize it.
Yep.
USB drive,
yes.
how do you recognize it?
Because after I listened to it, I initially negative.
Okay. All right. And when you listened to it, it contained 3 separate phone calls from utilizing the PIN number from the defendant, Romeo Johnson. And do you have any reason to believe that those 3 phone calls were any way altered or manipulated or changed?
Yes,
And with regard to those 3 phone calls, were they placed on 3 separate or broken out into 3 separate USB drives?
yes,
And on those USB drives were what's referred to as subtitles added to the to that particular recording.
yes,
In other words, words that are scrolling across there
yes,
as the recording is played. And but for the addition of those subtitles, do you have any reason to believe that the contents, the actual recording, was altered or manipulated in any way?
no, sir.
So I'm going to show you what I'm going to mark as State's Exhibit number 17. Again, USB drive, it's got your initials and the date on it that you listened to it, right?
Yes,
What date's on there fully listed?
4/28/26.
And for identification purposes, State's number 17 is referred to, it has a label on it that says number 3, but it is referring to a phone call ending in 1802-010. So that's State 17. States 18 will be another USB drive. And does it have, again, another one of the 3 recordings broken out with subtitles?
Yes, sir.
Initials, the date that you listened to it, right?
Yes,
Any reason to believe that it has been altered or manipulated other than the addition of the subtitles?
no, sir.
I'll mark that as State's Exhibit number 18. And for record purposes, I'll represent to the court that it bears a label that says number 4. And number 4 corresponds to the phone call ending in 02-002. And lastly, I have a third phone call here from that original USB that contained all 3 that has the addition of subtitles. And does it also bear your initials and the date you listened to it?
Yes, sir.
And when you listen to it, any reason to believe that it had been, other than the addition of the subtitles, altered or materially changed?
No, sir.
And I'll mark that as State's Exhibit number 19. And for record purposes, that USB drive has on it a label that says number 5, and number 5 corresponds to the identifier given by the jail ending in 07-055. With that, Your Honor, I will tender into evidence States 16, 17, 18, and 19, which have all been previously provided to defense counsel in discovery. And for the record, I have provided him with a written version of the subtitles, and I'll tender to him for his inspection.
What other witness?
Sure.
Captain, for today, have you had any interaction with this defendant?
Yes, sir.
When there are calls made from the jail, is it the case that some inmates will, because of various restrictions, use other inmates' PIN numbers to speak to people?
Yes, sir, it does happen.
Okay, and with regard to these subtitles that were added to these calls, did you add those subtitles?
No, sir.
Can you sit here and tell this jury in this court with 100% certainty that these subtitles are exactly what's said on that video or that recording?
No, sir.
And with regard to the recordings, what the state would want to offer as statements of the defendant are statements of the other person on the recording also included in these recordings.
Yes.
All right, non-object and proper foundation, hearsay, and relevance.
Mr. Coleman?
There's my understanding of the hearsay objection, at least, is that that is not unlike with a 911 call, where the hearsay objection is inapplicable, as it is a jail phone call that courts routinely admit into evidence. It is certainly non-testimonial, and it is contextual, so that the trier of fact can understand what the defendant is actually saying and responding to.
So what about I'm gonna overrule the objection with regard to hearsay. I'm gonna overrule the objection with regard to relevance. I'm going to overrule the objection, all objections on 16. 16's admitted. My issue is with the subtitles and who put the subtitles on, and if that's, I feel like that could be a potential issue.
I added subtitles, Your Honor, and I provided a copy of the timestamp and what the word that I've added to the video or to the recording. I provide that to the defense counsel.
So I received this just a few minutes ago, and as I represented to the court earlier, I was looking for these calls prior to this proceeding beginning. I advised counsel that I could not locate them. Counsel's response to me was to say that somebody from my office signed for it on January
So
30th.
I'm not worried about that. The subtitles themselves, you were given that just today.
Just now.
Okay, so I'm gonna sustain the objection to 17, 18, and 19.
Your Honor, I will say this, those phone calls are almost indiscernible without those subtitles.
All the more.
I think that's, if you can discern them, then the jury will have to do their best to discern them as well. So, 17, 18, and 19, I sustain the objection, 16's admitted.
Permission to publish, sir?
Yes, sir. And you can also, so the way it works right now is we just have sound coming out of this TV. So if you want, you can get the, I don't know where it would sound better, if it would sound better coming from behind them also, sometimes that gets a little. Just try it and let's see where it sounds best, but we can adjust because the sound's actually coming from the TVs, not the speakers in the ceiling.
Judge, I think this is what I'd like to do. It's in evidence, the jury can listen to it. I'd like to just argue what I believe said on the video, and then if they choose, they can listen to it. If that's okay with the court.
It's in evidence, they can have that
Yes,
opportunity.
ma'am. Phil, I think that's what I'll do. Thank you. I have no further questions for this witness, Judge.
Thank you. Any questions of this witness?
Just want to follow up on something.
You stated that inmates will sometimes use other inmates' phones due to various restrictions. Are you absolutely certain, as you sit here today, that one of the voices contained on each of those calls belongs to the defendant, Romeo Johnson? Move court reconsider, Your Honor.
Yeah, it goes to the weight, not the admissibility.
I agree. Anything else?
No, Your Honor.
All right, thank you, sir. You're excused.
Stay rest at this.
All right, thank you. Any,
Judge, may I reopen? Mr. Smith pointed something out to me. Is these, it's just these, out of an abundance of caution, the actual judgments that I do have, just want to bring them in, that's okay. 21, 21, 22, 23. Okay. I'm marking 6, 20, 21, 2, 1, 3, and for purpose of the record, I'm tendering to defense counsel for his inspection. Certified copies of of certain judgments.
So same objections as previous.
Would you also please hand me that, is it 15, the big one?
This, I think,
Hand me 10, no, 11 and 12, please.
10, 11, and 12.
Thank you very much. Appreciate it. Should I don't need to? Okay, based on the identifiers that have been already looked at from states 10, 11, 12, and 13, and 15. All of the identifiers also match on states 20, 21, 22, and 23. They all have the same state identifier number of 07111-416, the same names and or AKAs with a couple of variances of some additional AKAs. And everything else again matches. So that objection is overruled. With regard to 20, 21, 22, and 23, they're all admitted. All right.
No further state arrest in question, Judge.
Thank you, Mr. Wilkerson. Any witnesses?
Defense restaurant.
All right, so ladies and gentlemen, what that means, you now have heard the evidence with regard to punishment. I've got the charge prepared. I just haven't been able to give it to the attorneys yet because things moved a little quickly. This should not take longer than about 10 or 15 minutes. I'm going to give it to them, let them go through it. It's pretty straightforward. So it's 3:35, we'll try to get started close to 3:45, 3:50. So just kind of stay close if you can. For everyone else, please remain seated. You're excused for about 10 or 15 minutes. Did I print? All right, I'm about to print 3 copies. Okay, thanks. All right, the copies of the charge are printing now. They'll bring them in. You guys take a look at them. Everything it's pretty straightforward. So shoot. I just saw a message. I just saw something. What's that? Okay. All right, so we'll be in recess for about 10 or 15. All right, state's attorneys present, defendant and defense counsel are present. Before we bring the jury in, is there anything we need to take up, Mr. Wilkerson?
Your Honor, defense would move to reopen the case briefly to present testimony from the defendant in this case.
No objection.
All right, I will allow you to do that. I have given you both a copy of the court's proposed charge. Any issues, requested additions or objections to that charge?
Nothing stated.
Nothing from the defense, Your
I
Honor.
wouldn't imagine that anything would change after that testimony. And so my goal would be to do that, read the charge and go straight into closing argument without another break.
5 minutes.
Okay, you can bring the jury in. All right, let the record reflect the jury seated, state's attorneys present, defendant and defense counsel are present. And ladies and gentlemen, while you were out, the defense has requested to briefly reopen the punishment phase and allow his client to testify. That was without objection from the state, and so I'm going to allow him to do that. Mr. Wilkerson, Mr. Johnson, you can come on up and please keep it brief.
Yes.
Thank you very much. Mr. Johnson, you, well, you have been incarcerated since the inception of this case, is that correct?
Yes, sir.
In the Jefferson County Correctional Facility.
Yes, sir.
Can you just briefly kind of explain the personal growth that you've experienced and realizations you've had since you've been in custody?
Oh, I believe out in 2024, maybe around like February. I changed, I really changed, in my life to Christ. But I was in and out, one foot in this, one foot doing that. So when I got incarcerated the first time, it really was an eye opener. Like, you know, I don't know if God tested me to do this or whatever it was, but as I was going through it, I've matured, I've developed, I've been in my word. All I do is read it. Whole Bible study Monday, Wednesday, and Friday. I mean, that's not a thing, just me, but that's what I do, and it's just really matured me. You know, made me see things from a different perspective.
The jury has heard a lot about some past criminal conduct. Back during most of that conduct, were you actively, well, were you a person with a substance abuse disorder?
Yes, sir.
And did not that, and I think you realize, well, you don't think that that justifies what happened in the past, do you?
No, sir.
Oh, you take full responsibility for
Yes, sir.
those. And I believe you testified earlier that you, aside from the present allegations, in the past, when you've messed up, you've kind of accepted responsibility for that. And so in terms of the changes that you've undergone, do you believe that once you are discharged, however that may be, whether parole or otherwise, that you will be able to continue on the good path, so to speak?
Oh, yes, sir. Well, whether, you know, found me guilty or not, I pray for each and every last one of you. I thank God for you, for your time. And yeah, I've just really grown. So it's no grudges, it's no, you know, it's just it's acceptance. I accept because that's what God would have me do, and that's what I would do. And yeah, once I get out, I'm trying to be productive in the community. Uh, I see a lot of things on TV as with the violence, with the, you know, no guidance. At one point, me and my brother, when I did get out, we had started to put the guns down, pick the gloves up, and we had youth coming, and that's what they was doing. They was training, you know, trying to show them discipline. And when he furthered along, he had little league things, but I feel that they was positive role models to me. I mean, some situations was kind of beyond my control, but I was, you could say, wrong place, wrong time type of thing. And but I accept all things. I accept it all. And I'm growing, I grow from it. I'm better. I give God the glory. So
And with regard to during the guilt innocence phase of the trial, we heard from Mr. Cooper that that life that you were engaged in back when most of your charges arose, is that when you got to know Mr. Cooper?
I've been knowing Daryl for over 15 years, but what really got me was how Darryl came on the stand as if I was some modern day Billy the Kid or something, or just taking him down or taking his money or hurting him in any kind of way. Me and that man never had a relationship. I've never touched him. I've never pulled a weapon on him. But I mean, who knows what he's dealing with to come up here and say things like that. I'm not mad at him either. It's just who knows what he had going on, who knows what he was told. It's just, it's acceptance. I mean, now I have to be dealing with that and trying to, face that and trying to get people to see that, well, I've never did anything to this man, as if he said I had a gun, but said he heard a slide, but it was no gun that he ever seen on me. Only thing he said that was truthful was that I was there. And that's one thing that really gets me, because when the dude did whatever he did to Mr. Cooper, I was sitting there, but just as shocked that he was, I was like, what are you doing? As you can see, he's an old man. He has no money. You see that now. I mean,
Mr. Johnson, can you describe briefly your support structure?
I have a family. Y'all seen him earlier. If y'all was paying attention, looked like Suge Knight. That was my brother back there. That's my oldest brother. It's 10 of us. Most of them work. But I have my mother. She's still living. My father, he's still living. They're older. They're elderly. My nieces, my two nephews just went to the army. One of my nephews is training to be a nurse, so doctor or something like that, a heart surgeon. And well, the family is, we always been a close knit family. It's 10 of us. We always been close knit. I call every last one of them. I call my mom. We always just been tight. We just, gets around and see us all outside and think it's a party, but it's not. It's just a family get together.
You indicated that, in the not too distant past, you have, rededicated your life to God, I believe is what you said.
Yes, sir.
Do you have a particular, place of worship that you intend to attend when, you are discharged or released?
Yes, sir. Macedonia Baptist Church is right off Gladys. It's small, but I've been to it a couple of times. It's powerful. Good word in there. The spirit is moving in there. And that's a place that has accepted me, and I still call the pastor. And he prays with me, and he give me things that I give back to others, kind of comment, feedback thing. And it's just a place that I'm gonna go when I get out.
I want to ask you about something, in part because of what the law specifies with regards to sentencing in these matters. Uh, do you recall the date that your incarceration began?
Uh, yes, sir. On my birthday, I went, reported, and turned myself in because I was a suspect in another case, and I volunteered to call them, turned myself in, gave my statement, and it's been since September 14th,
Of
2024.
2024. And so, while you have been in custody at Jefferson County, have you do you earn money when you're in there?
I work, and they do pay weekly. I worked at maximum security, where Captain Under is over. I worked at maximum security. They pay you $8 a week. I mean, it entitles some things that I'm pretty sure a lot of people wouldn't want to do, but yeah.
Right. And so in terms of ability to pay a fine, because you are in custody now, have been since 2024, and will continue to be until such time as you are discharged, everything that you're dealing with to be cleared up. Do you have the ability to earn the funds that would pay a fine of up to $10,000?
No, sir, no, sir. I wouldn't be able to obtaining funds. If I had $10,000, we don't really deny, he's probably fighting this from the world, or trying to settle this from the world, but no, sir, there's no way for me to pay $10,000.
I'll pass the witness, Shirley.
Thank you, Mr.
Those
Wilkerson.
questions for this defendant, Judge.
Thank you, Mr. Johnson. You can have a seat. Thank you, Mr. Wilkerson. Does the state, you have the right to, well, nope, I get to read the charge now. All right, so that is it then for punishment evidence. At this time, I'll read the court's charge and then you'll hear argument by counsel. Cause number 25, DCCR 1626, the state of Texas versus Romeo R. Johnson, AKA Romeo Randolph Johnson, jury instructions. Members of the jury, you have found the defendant Romeo R. Johnson, AKA Romeo Randolph Johnson, guilty of the offense of unlawful possession of a firearm by felon. Now you must determine the punishment to be imposed on the defendant. The parties will soon present final arguments on what? Am I doing wrong?
Argue first.
No. I read the charge and then you argue because y'all talk about the charge.
Yeah, she's right. You're wrong. She's right.
The record get that?
Yeah.
It's been a long day, but okay. The parties will soon present final arguments on punishment. Before they do so, I must now give you the instructions you must follow in determining the defendant's punishment. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable to this case. General principles. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. In determining the sentence to be imposed on the defendant, you may take into consideration all the evidence admitted before you. This includes the evidence admitted during the first stage of the trial concerning the defendant's guilt, as well as any evidence admitted during this punishment stage. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you are told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits, if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request the testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that's in dispute. During the trial, you heard evidence that the defendant may have committed wrongful acts that did not result in any criminal charges or that did not result in criminal convictions. You are not to consider any evidence of any particular wrongful act unless you find beyond a reasonable doubt that the defendant did, in fact, commit that wrongful act. Those of you who believe the defendant did the wrongful act may consider it. You must arrive at the amount of punishment by a full, fair, and free expression of the opinion of the individual jurors. You must not decide punishment by lot or by chance. For example, you may not agree beforehand to be bound by the result of a procedure by which each juror gives the number of years the juror thinks should be served. These are then added and the result is divided by 12. To reach a verdict, all 12 of you must agree. Rules that control deliberations. You must follow these rules while you're deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. The forepersons should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, you must stop your discussions about the case until all of you are present again. 3, you must not communicate with the judge. You must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments. 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to the particular form that conforms to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Specific law applicable to this case. You have found the defendant, Romeo R. Johnson, aka Romeo Randolph Johnson, guilty of unlawful possession of a firearm by a felon. The state has accused the defendant of having been convicted of a felony once before. The defendant has pleaded that this accusation is not true. The range of punishments from which you must assess the defendant's punishment depends on whether you find the state has proved the prior conviction accusation. If the state does not prove the accusation of a prior conviction is true, this offense is punishable by 1, any term of imprisonment for no less than 2 years and no more than 10 years, or 2, any term of imprisonment for no less than 2 years and no more than 10 years, and a fine of no more than $10,000. If the state proves the accusation of a prior conviction is true, this offense is punishable by 1, any term of imprisonment for no less than 2 years and no more than 20 years, or any term of imprisonment for no less than 2 years and no more than 20 years, and a fine of no more than $10,000. Robbery is a felony offense. The state must prove beyond a reasonable doubt the prior conviction accusation. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, the defendant, if sentenced to a term of imprisonment, may earn early parole eligibility through the award of good conduct time. Prison authorities may award good conduct time to a prisoner who exhibits good behavior, diligence in carrying out prison work assignments, and attempts at rehabilitation. If a prisoner engages in misconduct, prison authorities may also take away all or part of any good conduct time earned by the prisoner. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served plus any good conduct time earned equals 1/4 of the sentence imposed. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law and good conduct time might be applied to this defendant if he's sentenced to a term of imprisonment, because the application of those laws will depend on decisions made by prison and parole authorities. You may consider the existence of the parole law and good conduct time. However, you are not to consider the extent to which good conduct time may be awarded to or forfeited by this particular defendant. You are not to consider the manner in which the parole law may be applied to this particular defendant. Application of law to facts. You must determine whether the state has proved beyond a reasonable doubt 3 elements of its accusation of a prior conviction. The elements are that 1, the defendant was convicted on March 9th, 2015, and cause number 14-21127 in the District Court of Jefferson County, Texas. And 2, this conviction was for robbery, a felony. And 3, this conviction became final before the commission of the offense for which the defendant was convicted in this trial. You must all agree on elements 1, 2, and 3 listed above. If you all agree the state has failed to prove beyond a reasonable doubt one or more of elements 1, 2, and 3 listed above, you must find the prior conviction accusation is not true. In this event, you are to determine and state in your verdict 1, the term in prison to be imposed on the defendant for no less than 2 years and no more than 10 years, or 2, the term in prison to be imposed on the defendant for no less than 2 years and no more than 10 years, and a fine of no more than $10,000. Excuse me. If you all agree the state has proved beyond a reasonable doubt each of the 3 elements listed above, you must find the prior conviction accusation is true. In this event, you are to determine and state in your verdict 1, the term in prison to be imposed on the defendant for no less than 2 years and no more than 20 years. Or 2, the term in prison to be imposed on the defendant for no less than 2 years and no more than 20 years, and a fine of no more than $10,000. And then that has my signature on it. And then the final page is the verdict sheet. There's 2 different options. The top is titled Verdict, Accusation of Prior Conviction Not True. We, the jury, having found the defendant, Romeo R. Johnson, aka Romeo Randolph Johnson, guilty of the offense of unlawful possession of a firearm by felon, find that the accusation of a prior conviction has not been proved true. We assess the defendant's punishment at, and then there's 2 options. You'll select one. The first, imprisonment in the Texas Department of Criminal Justice for a term of blank, 2 to 10 years and no fine. Then the second is imprisonment in the Texas Department of Criminal Justice for a term of blank, 2 to 10 years, and a fine of blank, $10,000 or less. Then the second option is verdict, accusation of prior conviction true. We, the jury, having found the defendant, Romeo R. Johnson, aka Romeo Randolph Johnson, guilty of the offense of unlawful possession of a firearm by felon, find that the accusation of a prior conviction has been proved true. We assess the defendant's punishment at, and then you would select one of these. The first is imprisonment in the Texas Department of Criminal Justice for a term of blank, 2 to 20 years and no fine. And then the second is imprisonment in the Texas Department of Criminal Justice for a term of blank, 2 to 20 years and a fine of blank, $10,000 or less. Each of those also has the signature line and the line for the printed name of the foreperson. So you pick one and then you pick one within that one. Mr. Coleman, you have the right to open and close argument.
State was his right to open, reserve your right to close.
Thank you, Mr. Coleman.
May we approach very briefly? It'll be the last time.
Sure. Proceed.
Thank you, Carol. Ladies and gentlemen, it's been a long few days. And I meant what I said earlier, thanks earlier. I meant what I said earlier when I told you that what your verdict would be justice. I still believe that. I would be lying if and intellectually dishonest if I tried to tell you anything other than that we'll just plainly the verdict, but you followed your oaths, you followed the law, and ultimately the end result was finding you guilty. So now you have the responsibility, the non-enviable responsibility, in my opinion, of deciding what punishment fits the offense. And when you begin to assess punishment with regard to an offense, what I suggest you submit to you is that you need to consider all of the circumstances with regard to that offense. And in this particular case, obviously the jury decided to believe that there was a firearm that was exchanged between Mr. Smith and the defendant.
Um, but what I would advise you, what I would implore you to consider is the brief amount of time for which the defendant had what you've determined to be a firearm before it was returned to Mr. Smith. As the defendant asserts was the case. In terms, and he spoke in terms of the gun, but and so now, with all of that in mind, obviously, you're asked to consider also the defendant's criminal history. And there is no doubt that I'm not going to try and whitewash anything to you that in his young years and leading even up to these incidents, he has had issues with criminal offenses. Those issues have been born of substance abuse. And unfortunately, we find often in our lives that substance abuse is a disease that touches everybody, but in some way or another. I imagine we all know someone who has had problems with substance abuse. I know, in my family, that problem existed, and I know my brother would pawn the belongings of myself and other family members, and that was difficult to deal with. But I do think that we know that people who find themselves in desperate situations and are not thinking clearly often do things that they might not otherwise do. And so I would ask you to consider that when you're assessing punishment. You are allowed, of course, to consider the fact that at some point, the defendant at some point after the defendant's time reaches a quarter, his good time and his actual time reaches 1/4 of his sentence, who is eligible for parole. However, we obviously don't know that will in fact be granted. The parole process involves, review by a board. They often set off, meaning deny parole, to inmates and, set them for review anywhere from, from 3 years to a year in the future. In some events, they just have to decide to parole someone, but still require them to undertake a 6-month program or 9-month program before getting there. And so obviously none of that is guaranteed. And in terms of doing justice, when we talk about that, it is a process. Sitting in judgment of someone else is not easy. And, I'm not going to presume that any of you have acted in any way except the utmost good faith and strong consideration of all the facts that we're presuming. All I ask is that you continue to do that. That even in considering this defendant's history, that you also consider the circumstances in which that history arose. I think it's important, and I believe the defendant in this case is sincere when he tells you that since he's been incarcerated, somewhat, nobody who deals with, for instance, substance abuse issues can ever say, I guarantee I'll never do that. Anybody with a substance abuse disorder has another relapse and not always another clean time, And so I can't stand here and guarantee to you that, the defendant, once discharged or once paroled won't ever fall into that. What I can tell you though is I believe that given the amount of time that he has been clean and given the additional time that he'll serve, and given his refocus of his life, that he will come out better rather than worse. And so I ask you to consider all of that in assessing punishment in this case.
Thank you, Mr. Wilkerson. Mr. Coleman?
Thank you, Your Honor. May it please the court, counsel, ladies and gentlemen of the jury, your verdict is very much appreciated, and I do believe you've reached the correct verdict. I have no doubt that you did it right on the punishment end. Speaking of the punishment end, at the risk of sounding too jaded, if you've done this for any length of time, this criminal prosecution business, you hear some of the same things over and over. One of those things is that, defendants, inmates often find Jesus in the jail. I truly hope that this defendant has made that transformation. But again, you hear that a lot. There's a saying that if you really want to find Jesus, you know where to find him, you go with the jail. Because that's where the defendants find it. I will submit for your consideration that the jail phone calls that are in evidence are in odds with the defendant's representation that he found Jesus in the jail. They're in evidence. There are 3 phone calls. If you want to listen to them, you can. My interpretation of those from listening to them, again, it's my interpretation. You can listen firsthand for yourself. One of those phone calls, it sounds like he's setting up a drug deal from jail.
Objection based province of the jury.
Overruled.
Sounds like he's setting up a drug deal from jail. He begins by saying, "Hey T, I got in touch with old boy with the cocoa. He said, what you trying to do? I'm trying to get some bread. He said, I am going to do you a fair price for the cocoa. I got my list ready so I can go in there and place my order." I'm summarizing from different portions of the conversation. But he says, "I'm finna let him know that you say, just let him know what the order is." On another jail phone call, there's a portion in there where he says, this is on a different day. He says, "Tell him it's good. I'll let you know about the cocoa tomorrow." And lastly, on the 3rd jail phone call, it's in evidence if you care to listen to it. A little lengthier, but he talks about an individual named Old School. He says, "Old School wanted to get some dope, so I gave it to him. Hey man, Old School want another 20. So Old School owed me 40. Binky came in and I was like, I got somebody, got $10. I'm like, all right, bang. Man, I was giving Cool pounds, ounces, I'm giving them today. I gave, sitting in there, smoking it up. I'm giving Za, I believe, an ounce. I'm sending ounces for 100. Look, brother, just bring me back 35. Again, these are calls made from the jail while he's sitting in jail, and he's professing to you that he found Jesus while in jail. And I submit to you that's not necessarily consistent with the testimony. Another thing I want you to think about is, I don't want you to think that there was a bait and switch. I know during the jury selection, we talked about the punishment range in this offense being from 2 to 10 for the unlawful possession of a firearm for this defendant. I couldn't necessarily tell you that it was 2 to 20 because he also had another robbery conviction. We feel like that would be prejudicial to this defendant for me right out of the gate to tell you he's got 2 previous convictions for felonies. In other words, the unlawful possession of a firearm by a felon is predicated on that felony evading arrest or conviction that he had. Then there's also the felony robbery that he had, which bumps up that offense from 2 to 10 to 2 to 20. So we feel like would be unfair for the defendant if I right out of the gate say, oh, he's 2 to 20 because of the 2 prior felony convictions. But if you find that robbery conviction true, then it makes his punishment range from 2 to 20. And while we're talking about prior convictions, all of the convictions that I'm relying on are in evidence. And if you wanted to look at them, you can. By way of summary, there's also a summary in there, and I just run through them really quickly. A 2004 evading, 2004 robbery, 2007 evading. These are all convictions, mind you, that There was some form of evasion. 2008 evading, 2008 criminal trespass, 2011 criminal trespass, 2011 evading, 2011 possession of a controlled substance, 2012 theft, 2012 manufacture and or delivery of a controlled substance, 2013 possession of a controlled substance, 2015 robbery, 2022 evading, and 2008 unauthorized use of a motor vehicle for which he had his probation revoked. He served 4 years on the evading. He served 5 years on the 2015, or at least he was assessed 5 years on the 2015 robbery, which dovetails into what the ask that I'm making of you is, as you're considering the appropriate punishment in this case, that you consider that criminal history and that you consider the fact that at some point he has served, or at least was assessed 5 years in prison, and that was not enough to change his criminal behavior. I am of the belief that the punishment should not go down. If you continue to commit criminal offenses, it should go up. And I'd ask you to consider that in assessing your punishment, anywhere from between 2 to 20 years. Don't worry about the fine. There's gonna be language in there that you can assess a fine of $10,000. Here's the deal. Even if that fine gets paid, it won't go to any victims. It won't even, I don't know what the state does with it. I believe it goes into the general fund. I don't want you spending a lot of inordinate time back there thinking about, deliberating about what the appropriate fine is. I would ask that you not even assess a fine. But what I will ask is that you find, at least at a minimum, that the robbery to be true, and that you assess his punishment within the 2 to 20 range, and that you consider the fact that he may be eligible for parole after serving a quarter of the time of whatever you assess. So what you cannot do, and what the jury charge says you can't do, is you can't, and I'm just gonna read it, you cannot consider the existence of the parole law as it would be applied specifically to this defendant. You can just consider the fact that he may be eligible after serving a quarter of the sentence you're assessed, but you cannot say for certain that this is what he's done to do, because that's determined by the parole board. You have no control over that. We don't know what the parole board's going to do. You can't consider the fact that he may be eligible. I'll just end by saying this: you got it right with punishment. Excuse me, you got it right with guilt or innocence. I have no doubt you'll get it right with punishment. I'm asking you to do just that, assess the appropriate punishment.
Thank you, Mr. Coleman. All right, ladies and gentlemen, you have heard all of the evidence, the court's charge and closing argument. I'm handing the charge to the bailiff. She will get you settled back in the jury deliberation room, where you will begin your deliberations, and will be in recess until you reach a verdict. Anna texted me earlier. Before we take a break, also at this time, I didn't do it before. Obviously, Mr. Johnson is not in custody, but I am going to revoke any bond amount that is set. There is no bond at this time.
Judge, there's a motion on the tab with regard to the other case, the aggravated robbery.
Okay, thank you. I'll take care of that.
I also have these, Your Honor.
What are they?
It's the election that you asked me to take care of
Thank you.
and the discovery certification.
And is there attachment with that
I
certification?
gave it to Ms. Warner already.
Thank you so much. All right, that's done. That's done. If you'll go ahead and get this kind of filled out, you may wait on the date just in case we don't get there today. But Mr. Coleman, did you have something?
So that's some, she needed these that were not admitted into evidence. No, right? They offered and then they weren't admitted.
I don't think I did.
All right, we'll be in recess.
That's your.
All right, let the record reflect state's attorneys present, defendant and defense counsel are present. I've received a message that the jury has reached a verdict on punishment. You can bring the jury in. Let the record reflect the jury seated, state's attorneys present, defendant and defense counsel are present at this time. I'll ask the foreperson, has the jury reached a verdict on punishment?
Honor with that.
And is it the unanimous decision of all of the members of the jury?
Yes, ma'am, Your Honor, it is.
Thank you, sir. You can hand it to the bailiff. Mr. Johnson, we, the jury, having found the defendant, Romeo R. Johnson, AKA Romeo Randolph Johnson, guilty of the offense of unlawful possession of a firearm by felon, find that the accusation of a prior conviction has been proved true. We assess the defendant's punishment at imprisonment in the Texas Department of Criminal Justice for a term of 15 years and no fine. You can have a seat. Does either party wish to have the jury polled?
State, Your Honor.
No, Your Honor.
All right, thank you. And so, is there any reason at this point not to pronounce sentence?
Not from the state.
Not from the defense.
All right, Mr. Johnson, then at this time, in conformity with the jury's verdict, I sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've already been in custody that the law gives you the right to receive. You can have a seat, sir. I've handed you two things already. The first is the trial court certification of your right to appeal. Obviously, this was not any type of agreement. You have a right to appeal. Mr. Wilkerson will talk to you about that. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you, obviously. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can also talk with Mr. Wilkers. At this time, I'm going to remand you to the Jefferson County Sheriff's Department until transportation to the Texas Department of Criminal Justice. And ladies and gentlemen, at this time, what that means is that the case is over. I'm gonna let them kind of get out of here for a second. I'm gonna come visit with you informally just for a few minutes. You'll be released from your instructions that you were previously given. We all appreciate your time. Thank you, Mr. Coleman, Mr. Smith. Thank you, Mr. Wilkerson. And at this time, you can take Mr. Johnson to the back. And court will be in recess. If everyone would please excuse yourself from the